After studying this module, you shall be able to know the SEBI's guideline issued on the public issue to protect investors' interest. The Security Exchange Board of India (SEBI) Act came into the force on 30th January 1992, and with its establishment, all public issues are governed by the rules and regulations issued by SEBI. SEBI was formed to promote fair dealing in the issue of security and to ensure that the capital markets function efficiently, transparently and economically in the better interest of both the issuers and the investors. The promoters should be able to raise funds at a relatively low cost. At the same time, investors must be protected from unethical practices and their rights must be safeguarded so that there is a steady flow of savings into the market. There must be proper regulation and code of conduct and fair practice by the intermediaries to make them competitive and professional. Under the umbrella of SEBI, companies issuing shares are free to fix the premium provided adequate disclosure is made in the offer documents. Focus being the greater investor protection, SEBI has become vigilant watchdog. We shall now discuss the SEBI guidelines on the public issue. Security and Exchange Board of India Disclosure and Investor Protection Guidelines 2000. First, eligibility norms for companies issuing securities. The companies issuing securities offered through an offer document shall satisfy the following at the time of the filing the draft offer document with the SEBI, and also at the time of the filing the final offer document with the registrar of the companies or the designated stock exchange. No issuer company shall make any public issue of securities unless a draft prospectus has been filed with the board through a merchant banker at least 30 days prior to the filing of the prospectus with the registrar of the companies. No company shall make public issue of securities unless it has made an application for listing of those securities in the stock exchange. No company shall make public or rights issue or an offer for sale of security unless the company enters into the agreement with the depository for the dematerialization of the securities already issued or proposed to be issued to the public or existing shareholders, and the company gives an option to the subscriber or shareholders or investors to receive the security certificates or hold securities in the dematerialized form with a depository. An unlisted company may make an initial public offering (IPO) of equity shares or any other security which may be converted into or exchanged with the equity share at a later date, only if it meets all the following conditions. The company has the net tangible asset of at least rupees 3 crore in each of the preceding 3 full years of 12 months each, of which not more than 50% is held in the monetary asset. Provided that if more than 50% of net tangible asset are held in the monetary asset, the company has made firm's commitment to deploy such excess monetary asset in its business or project. The company has a track record of distributable profits in the terms of Section 205 of the Companies Act 1956 for at least 3 out of the immediately preceding 5 years. Provided further that the extraordinary items shall not be considered for calculating distributable profits in terms of Section 205 of Companies Act 1956. The company has a net worth of at least rupees 1 crore in each of the preceding 3 full years out of 12 months each. In case the company has changed its name within the last 1 year, at least 50% of the revenue for the preceding 1 full year is earned by the company from the activity suggested by the new name, and the aggregate of the proposed issue and all previous issues made in the same financial year in terms of size, that is offer through the offer document plus firm's allotment plus promoter's contribution through the offer document does not exceed 5 times its pre-issue net worth as per the audited balance sheet of the last financial year. A listed company shall be eligible to make public issue of equity shares or any other security which may be converted or exchanged with the equity share at a later date, provided that the aggregate of the proposed issue and all previous issues made in the same financial year in terms of size, that is offer through the offer document plus firm's allotment plus promoter's contribution through the offer document, issue size does not exceed rupees 5 times its pre-issue net worth as per the audited balance sheet of the last financial year. Exemption from the eligibility norms in case of private sector banks which has received license from the Reserve Bank of India, public sector banks and infrastructure companies whose project has been appraised by the public financial institution or infrastructure development finance corporation or infrastructure leasing and financing services limited, or a bank which was earlier a PFI, rights issue by a listed company. No issuer company shall make a public issue or a right issue of convertible debt instruments unless the following conditions are also satisfied, as on the date of the filing of the draft offer document with SEBI and also on the date of the filing of the final offer document with the ROC designated stock exchange. Credit rating is obtained from at least one credit rating agency registered with the board and disclosed in the offer document. The company is not in the list of the willful defaulters of RBI. The company is not in the default of the payment of the interest or repayment of principal in respect of debentures issued to the public, if any, for the period of more than 6 months. Second, pricing by the companies issuing securities. The companies eligible to make public issue can freely price their equity shares or any security convertible at a later date into equity shares in the following cases. A listed companies whose equity share are listed on the stock exchange may freely price its equity share and any security convertible into the equity at a later date offered through a public or a right issue. An unlisted company eligible to make a public issue and desirous of getting its security listed on the recognized stock exchange pursuant to make a public issue may freely price its equity share or any securities convertible at a later date into the equity shares. An eligible infrastructure company shall be free to price its equity share subject to the compliance with the disclosure norms as specified by the SEBI from time to time. The banks, whether public sector or private sector, may freely price their issue of equity share or any other securities convertible at the later date into the equity share, subject to the approval by the Reserve Bank of India. Any unlisted company or a listed company making a public issue of equity share or securities convertible at a later date into equity shares may issue such securities to the applicants in the firm allotment category at a price different from the price at which the net offer to the public is made, provided that the price at which the security is being offered to the applicants in the firm allotment category is higher than the price at which the securities are offered to the public. Issuer company can mention a price band of 20%. Cap is the price band should not be more than 20% of the floor price in the offer document filed with the board, and actual price can be determined at a later date before filing of the offer document with ROCs. In case of public issue by the listed issuer company, issue price or price band may not be disclosed in the draft prospectus filed with the board. In case of right issue, issue price or price band may not be disclosed in the draft letter of the offer filed with the board. The issuer price may be determined any time before fixation of the record date in consultation with the designated stock exchange. Third, promoter's contribution in a public issue. In a public issue by an unlisted company, the promoters shall contribute not less than 20% of the post-issue capital. The promoter's shareholding after offer for sale shall not be less than 20% of the post-issue capital. In case of public issues by the listed company, the promoters shall participate either to the extent of 20% of the proposed issue or ensure post-issue shareholding to the extent of 20% of the post-issue capital. In case of composite issue of the listed company, the promoter's contribution shall, at the option of the promoters, be either 20% of the proposed public issue or 20% of the post-issue capital. Promoters' participation in excess of the required minimum contribution to be treated as preferential allotment. Promoters shall bring in full amount of the promoter's contribution, including premium, at least 1 day prior to the issue opening date 88, which shall be kept in an escrow account with the scheduled commercial bank, and the said contribution or the amount shall be realized to the company along with the public issue or proceeds. Exemption from the requirement of the promoter's contribution. The requirement of the promoter's contribution shall not be applicable in case of public issue of the securities by a company which has been listed on the stock exchange for at least 3 years and has a track record of dividend payment for at least 3 immediately preceding years. In case of companies where no identifiable promoter or promoter group exists, in case of right issues. Lock-in of minimum specified promoter's contribution in the public issue. In case of any issue of the capital to the public, the minimum promoter's contribution shall be locked in for a period of 3 years. The lock-in shall start from the date of the allotment in the proposed public issue, and the last date of the lock-in shall be reckoned as 3 years from the date of commencement of the commercial production or the date of allotment in the public issue, whichever is later. Fourth, pre-issue obligations. The lead merchant banker shall exercise due diligence. The standard of the due diligence shall be such that the merchant banker shall satisfy himself about all the aspects of offering, veracity and adequacy of the disclosure in the offer document. The lead merchant banker shall pay requisite fee in accordance with the Regulation 24A of Security and Exchange Board of India Merchant Banker Rules and Regulations 1992 along with draft offer document filed with the board. Memorandum of Understanding to be submitted along with the offer document by the lead manager. No company shall make an issue of security through a public or the right issue unless a memorandum of understanding has been entered into between a lead merchant banker and the issuer company, specifying their mutual rights, liabilities and obligations relating to the issue. The lead merchant banker responsible for drafting of the offer document shall ensure that the copy of MOU entered into with the issuer company is submitted to the board along with the draft offer document. The merchant banker shall not lead manage the issue if he is the promoter or the director or associate of the issuer company. Receipt of the queries from the SEBI or stock exchange if any, and make changes in prospectus if required. Reply to SEBI or stock exchanges in connection with the changes in the prospectus. Obtaining in principle approval from the stock exchanges. File final prospectus with the SEBI or stock exchange or ROC. Statutory advertisements. Submission of 1% of the security deposits with the regional stock exchange. Depositing promoter's contribution in the issue in the separate bank account. Fifth, contents of the offer document. In addition to the disclosures specified in Schedule 2 of the Companies Act 1956, the prospectus shall contain the following: the name, address of the registered office and the registration number of the issuer company, along with the address of the registrar of the companies where the issuer company is registered, the board of director of the issuer company, brief details of the chairman, managing director, whole-time director, etc. The names, addresses, telephone numbers, fax numbers and email addresses of the company secretary, legal advisor and banker to the company. The name, addresses, telephone number, fax number and email address of the compliance officer. The names, addresses, telephone number, fax numbers, contact person, website addresses and the email address of the merchant bankers and co-managers. Registrars to the issue, bankers to the issue, brokers to the issue, syndicate members. The names, addresses, telephone numbers, fax numbers and the email addresses of the auditors of the issuer company. The credit rating obtained from a credit rating agency for the proposed issue of the debt security including the convertible instruments. The capital structure shall be presented in the following manner: authorized, issued, subscribed and paid up capital, number of instruments, description and aggregate nominal value, size of the present issue, giving the separately promoters contribution, firm's allotment, reservation and for the specified categories and net offer to the public. Number of instruments, description, aggregate nominal value and issue amount shall be given in that order. Names of the group's company to be given. In case of reservation has been made for the shareholders of the group companies, applicable percentages may be given in case of book built issue, paid up capital. Sixth, post-issue obligations. Irrespective of the level of subscription, the post-issue lead merchant banker shall ensure the submission of the post-issue monitoring reports as per format specified in the Schedule 16. These reports shall be submitted within the 3 working days from the due dates. The due date for the submitting post-issue monitoring report in case of public issue by listed and unlisted companies. 3 days monitoring report in case of issue through the book building route for book built portion. The due date for the report shall be 3rd day from the date of allocation in the book built portion or 1 day prior to the opening of the fixed rate portion, whichever is earlier. 3-day monitoring report in other cases including fixed price portion of the book built issue. The due date for the report shall be the 3rd day from the date of the closure of the issue. Final post-issue monitoring report for all the issues. The due date for this report shall be the 3rd day from the day of listing or 78 days from the date of closure of the subscription of the issue, whichever is earlier. Post-issue lead merchant banker shall ensure that in all issues, advertisements giving details relating to the oversubscription, basis of allotment, number, value and the percentage of all application date of completion of dispatch of the refund orders or instructions to the self-certified syndicate banks by the registrar, date of dispatch of certificates and date of filing of the listing application is realized within 10 days from the date of completion of various activities, at least in an English national daily with wide circulation, one Hindi national newspaper and a regional language daily circulated at the place where registered office of the issuer company is situated. Basis of allotment. In a public issue of security, the executive director or managing director of the designated stock exchange along with the post-issue lead merchant banker and the registrars to the issue shall be responsible to ensure that the basis of allotment is finalized in the fair and proper manner in accordance with their guidelines. Allotment shall be on the proportionate basis within the specified categories rounded off to the nearest integers subject to a minimum allotment being equal to the minimum application size as fixed and disclosed by the issuer. A minimum 50% of the net offer of the security to the public shall initially be made available for the allotment to the retail individual investors as the case may be. The balance net offer of the securities to the public shall be made available for the allotment to the individual applicants other than the retail individual investors and other investors including corporate bodies, institutions, irrespective of the number of shares, debentures, etc. applied for. The unsubscribed portion of net offer to any of the categories specified in A or B shall or may be made available for the allotment to the applicants in other category if so required. The basis of allotment shall be signed as a correct by the executive director, managing director of the designated stock exchange and the public representative where applicable, in addition to the lead merchant banker responsible for the post-issue activity and the registrar to the issue. The designated stock exchange shall invite the public representative on the rotational basis from out of the various public representative on the governing board. The lead merchant banker shall ensure that the dispatch of the share certificate, refund orders and demat credit is completed and the allotment and listing documents submitted to the stock exchange within 2 working days of the date of allotment. The post-issue lead manager shall ensure that all steps for the completion of the necessary formalities for listing and commencement of the trading at all stock exchange where the securities are to be listed are taken within 7 working days of finalization of the basis of allotment. Lead manager banker shall ensure payment of the interest to the applicants for the delayed dispatch of the allotment letters, refund orders, etc. as prescribed in the offer document. No company shall make any further issue of the capital in manner whether by the way of issue of bonus shares, preferential allotment, right issue or public issue or otherwise during period commencing from the submission of the offer document to the board on the behalf of the company for public or the right issue till the securities referred to in the said offer document have been listed or application money refunded on account of non-listing or under subscription, etc. Subscription list for the public issue shall be kept open for at least 3 working days and not more than 10 working days. Guidelines on the book building. Book building means the process undertaken by which a demand for the securities proposed to be issued by a body corporate is elicited and built up and the price for such security is assessed for the determination of the quantum of such security to be issued by the means of notice, circular, advertisement, document or information memoranda or offer document. An issuer company proposing to issue capital through book building shall comply with the following. A. 75% of book building process. In an issue of securities to the public through a prospectus, the option of 75% book building shall be available to the issuer company subject to the following. The option of the book building shall be available to all body corporate which are otherwise eligible to make an issue of the capital to the public. The book building facility shall be available as an alternative and to the extent of the percentage of the issue which can be reserved for the firm allotment as per these guidelines. The issuer of the security through the book building process shall be separately identified or indicated as placement portion category in the prospectus. The security available to the public shall be separately identified as the net offer to the public and the requirement of the minimum 25% of the securities to be offered to the public shall also be applicable. In case of the book building option is availed of, underwriting shall be mandatory to the extent of the net offer to the public. one of the lead merchant banker to the issue shall be nominated by the issuer company as a book runner, and his name shall be mentioned in the prospectus. The draft prospectus to be circulated shall indicate the price band within which the securities are being offered for the subscription. On receipt of the information, the book runner and the issuer company shall determine the price at which the securities shall be offered to the public. The issue price for the placement portion and the offer to the public shall be the same. B. Offer to the public through book building process. An issuer company may make an issue of the securities to the public through a prospectus in the following manner. 100% of the net offer to the public through the book building process, or 75% of the net offer to the public through book building process and 25% at the predetermined through book building. A final book of demand showing the result of the allocation process shall be maintained by the book runner. The book runner and the other intermediaries of the book building process associated shall maintain record of the book building prices. The board shall have right to inspect records, books and documents relating to the book building process, and such person shall extend full cooperation. Now we shall recapitulate what we have learned so far. In India, a company planning to issue security shall abide by the relevant provisions of Security Contract Regulation Act 1956, Security Contract Regulation Rules 1957, Companies Act 2013, hereinafter referred to as an Act, and Companies Prospectus and Allotment of the Securities Rule 2014, Security and Exchange Board of India Act 1992, and the Rules and Regulations. In case of the public company which is listed entity or is desirous of the listing its security on the recognized stock exchange in India, the issue of securities is governed by Companies Act, Securities Contract Regulation Act 1956, the SEBI's Act 1992, and the issue of Capital and Disclosure Requirement Regulation 2009. In case of all issues by the private companies, the same is governed by the Companies Act, and the power of administration is exercised by the central government, the tribunal, or the registrar of the companies as the case may be. Section 24 of the Act empowers the Security Exchange Board of India to regulate the matters relating to the issue and transfer of securities and non-payment of the dividend by the listed companies or those companies which intend to get their securities listed. All powers relating to the prospectus, return of allotment, redemption of preference shares, and any other matter specifically provided in the Act shall be exercised by the central government, the tribunal, or the registrar of the company as the case may be. Further, the power relating to the forward dealing and insider trading has been delegated to the SEBI for listed companies or the companies which intend to get their securities listed. Securities and Exchange Board of India Disclosure and Investment Protection Guidelines 2000 deal with the protection of the interest of the investor.